Hello, everyone. My name is Kamisha Parkins. I am an associate in the New York City office of Von Schoeneck and King. My practice is largely with employment law as well as in the higher education space. And during today's webinar, I discuss the Retail Worker Safety Act, which was recently signed into law by our Governor Kathy Hochul on September 5th, 2024. The Retail Worker Safety Act requires certain New York retailers to adopt safety measures to both prevent and address workplace violence in retail settings. This new legislation, which amends the New York labor law, imposes requirements which are intended to protect retail workers at a wide range of small businesses and large-scale retailers. Now, most of the law's provisions will go into effect in March of 2025, with other requirements taking effect later. Covered employers under this act include any person, entity, business, corporation, partnership, limited liability company, or an association employing at least 10 retail employees. Now, these retail employees must work in a retail store that sells consumer commodities. What that means will be explained by the Department of Labor in a guidance document with details forthcoming regarding its release. The law explicitly states that retailers who primarily sell food for consumption on the premises are excluded, as well as employers of the state, employers of any political subdivision of the state, a public authority, or any other governmental agency or instrumentality. Some of the notable requirements that retail employers must keep in mind about for March 2025. First, a workplace violence prevention plan. Covered retail employers must adopt a plan that includes outlines of a number of factors or situations in the workplace that might place retail employees at risk of workplace violence. It must also include methods that the employer may use to prevent incidents of workplace violence. It should also include information concerning the federal and state statutory provisions concerning violence against retail workers, as well as include some remedies that would be available to victims. And it should also clearly state that retaliation against individuals who complain of workplace violence or the presence of factors or situations in the workplace that might place retail employees at risk of workplace violence is unlawful. Another requirement under the Act is an interactive workplace violence prevention training program. Now, the Act does outline what this training program should include, and I also do discuss that in depth during the webinar. Additionally, larger scale retailers, specifically employers with 500 or more retail employees, by January 1st, 2027, will need to provide access to panic buttons throughout the workplace. And the Act does define specifically what that panic button should look like or what it is. And these employers may install these panic buttons either in an easily accessible location in the workplace or provide all employees with wearable or mobile phone-based panic buttons that can only be installed on employer-provided equipment. And finally, I also discussed employer notice requirements that the Act imposes. So beginning March 1st, 2025, covered retail employers must also provide employees upon hire and annually thereafter a copy of their written workplace violence prevention plan, a site-specific list of emergency exits and meeting places in case of emergency, and employers must also provide a notice in writing in English and in the language identified by each employee as their primary language, which contains the employer's retail workplace violence prevention policy, and all information presented during the workplace violence prevention training program. Bond will continue to keep track of all updates as it pertains to this law and will provide further developments as they arise. Thank you.